Hello and welcome to the Minimum Competence episode for Thursday, April 3rd, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, SCOTUS backing the FDA on flavored vapes, Musk's likely exit from DGE, Trump's deal with Milbank, and a sweeping new U.S. tariff policy. Let's remember, you can always count on Americans to do the right thing after they've tried everything else, and read today's legal news. On this day in legal history, April 3rd, 1944, the United States Supreme Court delivered a landmark decision in Smith v. Allwright, reshaping the landscape of voting rights in the American South. The case centered on Lonnie E. Smith, a black voter from Texas who was denied the right to vote in the Democratic Party's primary election due to a party rule that only allowed white voters to participate. At the time, the Democratic primary was the only meaningful election in many southern states, as the party dominated politics, making exclusion from the primary tantamount to disenfranchisement. The Texas Democratic Party argued that, as a private organization, it had the right to determine its own membership and voting rules. However, the court, in an 8-1 decision authored by Justice Stanley Reed, held that primaries were an integral part of the electoral process and could not be exempt from constitutional scrutiny. The justices concluded that excluding black voters from primaries violated the 15th Amendment, which prohibits racial discrimination in voting. This ruling effectively overturned the court's 1935 decision in Grovey v. Townsend, which had upheld the use of white primaries. The Smith decision marked a critical step toward dismantling the legal architecture of Jim Crow voter suppression. While states continued to use other tactics to limit black political power, the ruling energized civil rights activists and laid the foundation for future litigation. By reasserting federal authority over state electoral practices, Smith v. Allwright signaled a turning point in the judicial battle against racial segregation and disenfranchisement. It also demonstrated the court's growing willingness to confront systemic racism in voting, a commitment that would deepen during the civil rights era. The case is remembered as one of the pivotal moments in the long struggle for voting rights in the United States. The U.S. Supreme Court largely upheld the FDA's authority to deny applications for flavored vaping products, supporting actions taken during the Biden administration under the 2009 Tobacco Control Act. The unanimous ruling rejected arguments from companies like Triton Distribution and Vapetasia LLC, which claimed the FDA unfairly imposed new testing requirements and ignored their marketing plans. These companies had applied to sell flavors like Suicide Bunny Mother's Milk and Cookies and Killer Custard Blueberry. The court found the FDA's approach consistent with its earlier guidance, despite claims from the Fifth U.S. Circuit Court of Appeals that the agency had pulled a regulatory switcheroo. Justice Samuel Alito wrote the opinion, agreeing with most of the FDA's decisions, but sending the case back to the appellate courts to reassess whether the agency erred in refusing to consider the company's marketing plans, an element the FDA had previously called critical for evaluating youth appeal. Though the ruling solidifies the FDA's regulatory role, its long-term impact is uncertain. President Trump, presumably in furtherance of his undying effort to always be on the wrong side of everything, has promised to, quote, save vaping, though his campaign never really clarified what exactly that means in terms of future regulation. The case, FDA v. Wages and White Lion, leaves the appeals court to decide whether any procedural missteps by the FDA were ultimately harmless. Elon Musk's time in Washington as head of the Department of Governmental Efficiency, or DGE, appears to be nearing its end. Both Musk and President Trump have hinted that his departure is imminent, with Trump noting that DGE itself will end. Originally designed as a temporarily advisory panel to cut federal costs, DGE has morphed into a more integrated part of the government, staffed with Musk allies tasked with canceling contracts and slashing budgets. However, signs of a wind-down are emerging. DGE staff are being reassigned to federal agencies, layoffs are underway, and the organization's influence seems to be diminishing. Musk, a special government employee limited to 130 working days per year, is approaching that limit, though neither he nor the administration has confirmed when his tenure will end. Musk's recent political involvement also took a hit when his preferred candidate for the Wisconsin Supreme Court lost, despite significant financial backing and a campaign visit. Tesla's 13% drop in quarterly sales adds further pressure. Trump praised Musk's contributions but acknowledged his corporate obligations, suggesting a graceful exit is likely rather than a public fallout. DGE had once shared leadership between Musk and Vivek Ramaswamy, but Ramaswamy left to run for Ohio governor. While Musk boasted about aiming to reduce the deficit by $1 trillion, critics say the group's progress has been way overstated. Despite speculation, Trump hasn't committed to keeping DGE operational post-Musk, indicating the administration may be moving to a new phase of governance. President Trump has announced a new agreement with law firm Milbank, marking another chapter in the growing divide among U.S. law firms over how to handle pressure from his administration. According to Trump's Truth Social post, Milbank initiated the deal, which includes a commitment to provide $100 million in pro bono legal services for causes like veteran support and combating anti-Semitism. The agreement comes amid a broader Trump administration effort to punish firms that have opposed or challenged his policies. Several law firms, such as Perkins Coie, WilmerHale, and Jenner & Block, have filed lawsuits seeking to block executive orders they claim were retaliatory and violated constitutional protections of free speech and due process. Federal judges recently issued a temporary block on parts of these orders. In contrast, other firms, including Paul Weiss, Skadden Arps, and Wilkie Farr, have opted for settlement-style cowardly deals with the administration to avoid similar sanctions. Milbank's chairman, Scott Edelman, reportedly described the agreement as aligned with the firm's values and praised the productive talks with the administration. This situation underscores a growing rift in the legal community. Some firms are resisting what they see as political coercion, while others are choosing cooperation to preserve their standing with the federal government and keep the money flowing. Today, President Trump took to the Rose Garden with a piece of oak tag to announce a sweeping new tariff policy during a press conference unveiling a, quote, reciprocal trade strategy aimed at countering what he described as decades of unfair treatment by U.S. trading partners. Holding a copy of a government report titled Foreign Trade Barriers, Trump declared that the U.S. will now impose tariffs that are approximately half the rate other countries charge American exports, but with a minimum baseline tariff of 10% and many rates going significantly higher. Countries hit with new tariffs include China at 34%, the European Union at 20%, Japan at 24%, Taiwan at 32%, Vietnam at 46%, and the UK at 10%. Trump also confirmed a 25% tariff on all foreign-made automobiles, stacking on the above-referenced rates effective at midnight tonight, and pointed to motorcycle tariffs as a key example of long-standing trade imbalances. He argued that U.S. manufacturers face rates as high as 75% abroad, while the U.S. imposes just 2.4%. The president justified the move as necessary to protect American jobs and industry, singling out countries like Canada and Mexico for benefiting from U.S. subsidies and defense spending. Detroit auto worker Brian Panebecker spoke in support, calling Trump's actions a hopeful step toward revitalizing shuttered factories. While Trump emphasized that the tariffs fall short of full reciprocity to avoid overwhelming allies, he made clear the era of what he called, quote, economic surrender was over. The announcement included plans to sign an executive order formalizing the new tariff regime, which boosted U.S. stock futures as markets reacted positively to the aggressive trade stance. Oh, no, I'm sorry. I got that wrong. Stock futures tanked. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. Reviews go a long way towards helping